All right, ladies and gentlemen, if you'll take your conversations outside, if you still need to have conversations, I understand some staff are still passing out things to members, and that will be continued, but we're running a little late, and I want to be as timely as possible, recognizing this is the last meeting for a lot of you on this Thursday afternoon. The first bill, a lot of these bills are I am the author of, and so in difference to other members, I'm going to call everybody else's bills before my bills. So the first bill I'm going to call is House Bill 499. We are working from LC 491247, and all members should have a copy of that. If you don't, raise your hand, and we'll make sure we get one to you. Thank you. Chairman Hitchens, you're recognized to present the bill.
Well, thank you, Madam Chairman and members of the committee. I'm about to introduce a bill that somewhat out of my bailiwick from what I typically get involved with, but sometimes in this job you just run into things that you see that are terribly wrong, and you take the opportunity to try and correct it. What this bill does is it deals with child support. And I work with a group in Effingham and Chatham County called the Navigators, and they call it the Navigators because they're children with disabilities. And the group comes together to help them navigate through the system, which all of us know is very bureaucratic and hard to decipher for many of us that worked in government for a long time and still can't decipher it ourselves. I get calls all the time that it takes a few phone calls for me up here to get somebody that can understand what the policy is and how you abide by it. But what this does, and I was personally offended when I found out that when you reach the age of 18, if there's a divorce in the family, the child support stops. If you have a child with a disability and there's a divorce in the family, the non-custodial parent can just walk away. They have no financial responsibility for the rest of that child's life. The custodial parent, on the other hand, is usually one that may not have the education opportunity, is not usually the breadwinner, and they have to fund it on their own. Now, there are some state benefits, but I've run into one or two cases where the person who is non-custodial and walked off is worth millions of dollars, and they won't contribute 1 cent. And I just think that it needs to be rectified, and that's what this bill does. It's a lifelong commitment. And it's beyond lifelong for some of them. In a lot of cases, a normal sibling ends up taking care of that child once the parent leaves or is deceased. And I'll take any questions. I appreciate the chairwoman calling this when I just introduced it it just had the second reading, I think, this morning. So
we try to be as expeditious as we can, Mr.
Well,
Chairman.
I certainly appreciate it.
And again, I'm going to be rude and just call you by your numbers. Number 3.
Thank you, Madam Chair. Just one quick question. This is in the case of when there's not a divorce, right? So you're just trying to cover this.
If there's a legal separation or divorce.
Oh, in the case of a divorce as well. Okay.
Right. No, it's primarily divorce, and for my involvement with about 11 years with this particular group, there's a lot of consternation. I think domestic tranquility escapes many of these marriages, and there are a lot of divorces, and some of them are very very arbitrary, and it just amazes me that people have children that they won't support, particularly those that very obviously need it. Their quality of life decreases very substantially.
Is that it, Representative? Okay. All right.
Yes.
Thank you. Number 4.
Thank you, Madam Chair, and thank you to the author. Just one clarifying question. I just want to make sure I'm understanding or reading this properly. So is this bill just simply is asking us to force someone to take care of a disabled child after the age of 18?
That's disabled and as it specifies in here, that is unable to care for herself. Most children, even in foster care, they walk out the door when they're 18 and they're on their own. But these people have no ability to live independently or much less earn any money. And some of the cases I've seen, and it's usually the wife, may not have an education that allows her. I've got one particular case where the lady now is trying to get a real estate license. Her husband's a multimillionaire. She won't contribute a dime. He won't contribute a dime. And her 85-year-old mother is taking care of the child. The 85-year-old mother isn't going to be around forever, and I don't know what she's going to do for child care once that happens if she isn't able to have some type of financial assets.
So how does that work? I guess I'm trying to understand. How does that work in the court of law? Does the judge just write an order, like once the...
It's just the same as they do for
So they have to demonstrate
Right.
disability.
It just continues on. There's a process that they determine whether or not they have the ability to be independent. But it just continues what happens with other people under the age of 18. It continues it on because it's a lifetime project. I mean, and unless somebody dies, they won't ever be able to take care of themselves.
Okay.
And
Thank you.
unfortunately, some of them get institutionalized.
Okay, thank you.
Okay, all right, thank you. Number 7.
Thank you, Madam Chairwoman, and thank you so much, Chairman Hitchens, for bringing this measure. I was looking, and some of the previous comments made me kind of ponder on, starting at line 62, it's the court's discretion. So it does allow the court discretion to order child support, the amount of the child support, the duration of the child support, based on the circumstance, correct?
Right, every case is different, and we rely on judges to make decisions like that all the time.
This just actually stipulates and gives the judge the ability to
That's
award
correct.
child support
That's
or
correct.
support of the adult disabled individual.
That's correct.
All right, thank you so much.
All right, thank you. Number 8.
Thank you, Chair. Thank you, Colonel. Appreciate the bill. Just from my understanding, so this would be to a parent, whoever was like potentially biological mother, father, or legal guardian, somebody that was given custodial responsibility that was connected in some type of a agreement or a marriage. So it could contemplate that if a step parent, so like a second or third marriage, and they were a legal guardian of that child, that the judge would have that discretion to also include. It goes beyond just that of the biological mother or father. Is that correct?
I don't know that, if it was a step parent, I don't know that they have that requirement unless they adopt them.
Well, so and
Yeah.
in my mind,
Right.
I've got constituents where there's a person that is technically a, I guess stepfather, but they adopted
Right.
the child and they are that child's father, and so and they're still married. But if they were to get divorced, the court could say, "Hey, look, you adopted
Good.
this child; it's still your
Right.
responsibility." Okay,
Right.
thank you.
All right, thank you. Number 16.
Thank you, Madam Chair. What is I guess let me put it this way. If the parent that is going to be ordered to pay this child support is unable to pay,
Well, again, that's up to the judge's discretion. They utilize the income of the parent that they're looking at. If they don't have any money or any means, they very obviously can't be required to pay anything.
and so
But-
what happens? Is there anything that,
Well, then the state takes some initiative and provides some benefits, but typically in most families, it's not to the level that it would be if the biological or adopted parent is contributing.
so is that, does the state currently automatically just kick in when that child?
Well, there are
turns-
programs for disabled children, and they do pay some. Medicaid, I think food stamps. It all depends on whatever level of income that the custodial parent has, but it's a lot of discretion to the judge,
Thank you.
and every circumstance is different.
Thank you.
Okay, thank you. Number 3.
Thank you, Madam Chair. Just a follow-up question. So I guess the first part of the bill, Section 2, deals with minor children if the parent leaves, I guess, right?
That's correct.
The
That's
first
correct.
part, lines 26 through 29.
Right.
So if someone reaches the age of majority, they would still continue to provide support. And then Section 3 deals more with if there is a divorce, And I guess the qualifying act is if there's a major life activity. So I can't work, I can't survive on my own. What happens if that person gets married, for example? So you have situations where someone gets married, and would they go back to the court? Would the parent go back to the court and ask for assistance?
I would think that the non-custodial parent would have every right to go back if their family income increases and he's assumed the responsibility or he or she has assumed the responsibility. I think they could petition the court and have it changed.
So I'm a parent, my child
Right.
gets married, I can go back to the court petition. Okay, that helps. And then the second piece is, does this impact the ability of that adult child to get assistance? So
It
if
says
they're
here,
looking
and
at
it
assistance,
it says not.
okay, so it won't impact the
Right.
assistance they get.
Right.
Okay, thank you.
Okay.
Because there's a lot of medical assistance beyond just normal care.
Gotcha.
Okay, thank you. Number 17.
Thank you. Thank you for this bill. If I could direct you to lines 68 and 68 through 70. It's the last page, page 4. It says the child support provided pursuant to this paragraph shall be in addition to and not in lieu of the benefits or assistance the child may receive from a source other than his or her parents. So I practice family law. So to determine child support, you take the gross income of the mother and the father, or generally the mother,
Right.
the two parents.
Right.
You add them up, and then you determine by the number of children. There's a formula, the
Right.
Georgia Child Support worksheet, and it spits a number out. Let's assume the number is $2,000 a month. If the child's already receiving $1,000 per month in benefits, you're saying now that the child's going to end up receiving $3,000 a month in benefits.
They could, but as a lawyer, I think you know that the judge would have wide discretion in that. And I'm sure they require some type of assessment of what each parent's income is.
The challenge is it says shall be in addition to and not in lieu of the benefits. That's my concern.
Yeah, and from my perspective, what I would think is the judge would reduce the amount of payment that the non-custodial parent had because they were receiving those. I mean,
But that's not what the bill says. The bill says the child support provided pursuant to this paragraph shall be in addition to. I mean, if it was may in addition to, I hear you. But shall is a requirement for the court.
and I have no objection to an amendment. I mean,
I think what they're saying, though, is it's not going to be in lieu of benefits or assistance. So I think that whatever monies, whether the child support worksheet dictates $1,000 and the judge reduces it to $500 because of other state benefits and other federal benefits that they're receiving, it will be on top of those benefits that they're already receiving. It won't take the place of.
it says exclude, but that's my assessment too.
Yeah.
The
I
judge is
think
gonna
that's
take
what that's
everything into
saying.
consideration.
Okay, number 11.
Thank you, Madam Chair. Thank you, Colonel, for this bill. But I have one quick question for you. Do you have any data or numbers of really how many people this is really going to affect?
No, I've just seen it in my community. I live adjacent to Savannah, and I represent this group, this navigators group, in conjunction with Georgia Southern, and there are probably 80 members, and I would say that the number of divorces or legal separations are more than the pro rata number in society as a whole. But I don't have any specific numbers.
Okay, because I think it'll help to have some data so we can kind of just get an idea of what we're looking at. If it's not just one little pocket here and then everybody else, or how many times this is happening with, disability,
I think it's universal. I mean, I just see within the community that there's a lot of angst in some of these marriages. It's like when one of the parties has a severe disability or something, it creates some turmoil that doesn't normally exist in regular marriages. I've dealt with some of them that have child that had long-term cancer tumors and ended up dying, and I don't know why, but it seemed like shortly thereafter they get divorced. And I think the wear and tear on the people, and people have different perspectives on things, just wears on them, and they go their separate ways.
Oh, okay. Thank you.
Thank you. All right, number 4. That's going to be the last question.
Thank you, Madam Chair. So I guess my question is kind of the reverse of the representative on the end. So could an unintended consequence be because of money that's awarded in the court, the child or adult that needs help, that can qualify for certain assistance, they be disqualified because they're getting too much assistance? Like, I guess I'm trying to understand.
And I really can't answer that with any authority. I would certainly hope not. But you know, they do have limitations, and we all deal with people from time to time that are trying to get some kind of benefits, and they make $5 too much, or I mean, they have cutoffs on everything. It's pretty arbitrary sometimes to deal with. But I don't know. You know, I just started this about 2 weeks ago. You know, I've seen it, but the one specific case I spoke to came to my attention, and the group as a whole came to me and asked me to intervene in their behalf.
Okay, I guess what I'm trying to think through is if
I would
the
hope
disabled
that doesn't
person is
occur.
not
I mean,
losing out on funds that they could need because they could get more money awarded to them which they're entitled to, as opposed to it being based on the income or
Right.
lower income of their
right.
family member.
Okay, thank you.
But we all know state benefits aren't really that substantial for people in need.
Okay, all right. This is the end of the questions. Seeing no more questions from the committee. What is the will of the committee on House Bill 499 LC 491247?
Move it to pass.
The vice chair moves to pass. There is a second from Chairman Camp. And number 11, do you want to be recognized for a motion?
Well, actually, I want to be recognized for a question. If you would call the question, I said I have one critical question, but
You can get with the author after we've already voted, because we've already called the question. So, okay. 17, do you have an amendment? Okay. All right. I'll recognize you. Let's see. There's been a motion and a second from Representative Camp. Are there any proposed amendments?
Yes. It would
Number
be-
17.
Thank you. It would be on line 68, the child support provided pursuant to this paragraph may be in addition to, as opposed to shall be in addition to.
Okay. All right. There is a motion that we insert may instead of shall on line 68. All those in favor of the amendment signify by saying aye.
Aye.
Okay, raise your hands if you're in favor of the amendment. 1, 2, 3, 4, 5. 5 in favor. All those against, please raise your hand. 6 against. Motion fails. So on the underlying motion, bill to pass, House Bill 49, LC 491247. Please signify by saying aye.
Aye.
Any opposed, like sign? Motion carries forward
Thank
with
you
a
very
due pass
much.
recommendation. Thank you, Mr. Chairman. Turn my mic off. The next bill that we're going to have is a bit of a special bill. It's a bill that we heard yesterday. We're bringing it back because we perfected it in committee. And we're going to have it come back through House Bill 144. Ms. Lewis Ward, she's going to be presenting LC 480877S, which is going to be presented as a committee sub. And Representative, if you'll just direct your questions to the changes that were made, rather than present the whole bill again, that would be appreciated by the chair.
Absolutely, and thank you, Madam Chair and members of the committee. We heard your concerns yesterday, and we've addressed those concerns. One of the concerns was that the bill did not specify whether it was for adults or children. That is specified on line 2. We added on line 10 different ways to communicate, which is to communicate was already in code. We added the different ways to communicate, which is really bringing it into the 21st century. And then in section 2, upon the Madam Chair's request to add violations for any penalties for any violations, that's included in lines 16 to 22. We'd appreciate your favorable consideration on this changes.
Okay. Those are the changes that are made to the bill. Is there any, does anybody have any questions regarding the amendments to House Bill 144? Seeing no questions, what is the will of the committee? There is multiple motions to pass and a second. All those in favor of the bill, please signify by saying aye.
Aye.
Any opposed, like sign? Motion carries.
Thank you so much. I appreciate everybody and their help.
Thank you, ma'am. Ladies and gentlemen, unfortunately or fortunately, the way that things work around here, sometimes we get bills kind of out of order. So I'm going to kind of work from the simplest to the biggest, and the ones that have signed up to speak the most on House Bill 460 and 462. So I'm going to be dealing with House Bill 409. House Bill 509, and the first one I'm going to call is House Bill 508. I'm working from LC 480859. And right now, if there's a temporary protective order that has been ordered in the state of Georgia, there is no shot clock. There's no time requirement for service onto the responding party. And it was thought by domestic violence folks from the commission to the coalition to the commission and the coalition that needed to change. Both are in support of the measure, and so basically it deliver it for service to the respondent within 24 hours of the court's issuance of such order. Now, obviously, this is going to be there's no penalty for not, because obviously the sheriff's office is not in charge of the world and can't just, kind of magic it into the respondent's hand. Sometimes the respondent actively tries to dodge service, but it just kind of creates that awareness that this should be dealt with very quickly, as quickly as possible. So I'll be happy to entertain any questions that the committee may have on this measure. Pertinent parts are on line 14 and 15. Number 4.
Thank you, Madam Chairwoman. So just confirming, if the sheriff's office does not have the proper staffing, or to your point, can't locate the person, there's no penalty, nothing happens. We're just trying to encourage something to happen within 24 hours.
Yes.
All right, thank you, Madam.
I recognize nobody signed up to speak on this wonderful piece of legislation that I'm working on. But if anybody from the audience would care to chime in on House Bill 508, feel free to take the podium. All right, seeing none, we'll close that. Number 15.
Thank you, Madam Chair. I'm just wondering if the intent of the bill was 24 hours after the issuance of the summons, or if it was, if business days were contemplated, or if it was a strict 24 hours.
It's just 24 hours.
Okay.
Unfortunately, our law enforcement works 24 hours. So we're trying to encourage that, because if somebody, say you get a temporary protective order issued on Thursday, Friday kind of rolls around, it's a little bit chaotic. Sometimes they won't try again until Monday or Tuesday. And by that time, several days have clicked on. So we're trying to avoid that. Number 17, you have a question?
Well, in support of your bill, you asked for audience comment, but I have comment. I do this work all the time, and this is very helpful. I've had clients who've had to wait days for the clerk to transmit the information for service, and it's awful. So thank you for bringing this bill forth.
Thank you. I appreciate your engagement. Number 9.
At the appropriate time, Madam Chair, I'd like to make a motion to pass.
Okay, I think seeing no more questions, now is the appropriate time.
Okay, I'd like to make a motion to pass.
Motion to pass from Representative Lott, second by Representative Wade. All those in favor of the any amendments? Seeing none. All those in favor of the gentlelady's motion will signify by saying aye.
Aye.
Any opposed, like sign? Okay, goes forward. Thank you very much. The second bill that I have, and I do apologize that I have all these bills. Well, I don't apologize. They're good bills. The second bill is House Bill 509. We're working from LC 480860. And I will be offering an amendment at the appropriate time. So right now, if somebody commits the offense of burglary when without authority and with the intent to commit a felony or theft, therein they enter or remain a dwelling. If they kick down the door, steal a clock, steal a toaster, and run out the door, they have committed a felony in the state of Georgia. If they kick down the door, beat the crap out of their ex-wife or wife that they're getting a divorce from, unfortunately, that's 2 misdemeanors. It's criminal trespass and it's also battery. So I think that women are worth a little bit more than a toaster. I am going to be changing at the appropriate time. I will be offering an amendment to include acts of family violence, including those offenses between current and former spouses, romantic partners, or family members. So we get out of, roommates sometimes because it's people that have cohabitated. We don't obviously want to get those people. So we will be offering that amendment at the appropriate time. And we'll be offering that amendment for line 21 as well. But does anybody have any questions? Yes, number 8.
Madam Chair, just a clarification. So, is family violence itself defined in code? And I apologize for I'm not an attorney.
Yes,
so.
it is. It's
Okay.
defined in the
All right.
criminal code, and there
Assume
are,
so.
there are specific offenses that are family violence, battery, family violence act.
All right.
So yes.
No problem. And so at the appropriate time, I'd make a motion to pass so we can consider the amendment.
Okay. Let's see. Number 16. Do you have a question?
Yes, thank you, Madam Chair. Can you share with us the broad time frame on line 14, not less than 1 year, no more than 20 years?
That's what's in existence now. That's current code.
That's that broad range.
It is. It's a very broad range. Burglary actually goes back to common law. It's been around for 1,000 years.
And do you further?
Yes, ma'am.
If you are including acts of family violence, can we amend that?
We can. There's nothing to preclude, an aggravation of punishment. There's nothing to preclude someone from getting, 5 years, 10 years, 15 or even 20. I believe and I have great trust in our judges and their judicial discretion to sentence appropriately. So I'm comfortable leaving that in as it is, because certainly our prosecutors and our law enforcement out there are going to be arguing for the tougher penalty. So
Thank you.
I'm comfortable with that. Number 3.
Thank you, Madam Chair. Can you so burglary, I guess we're saying you would commit that along with the act of family violence, or are we saying?
No, it's commit a felony or theft or an act of family violence. So if you go in, like say you're in an apartment complex and you kick down the door of one apartment and you steal a toaster, and then you kick down the door of the next apartment and your girlfriend lives there and you hit her, and then you leave, and then you go into another apartment and steal another toaster. You've committed 3 acts of burglary because you have committed a theft, then you've committed an act of family violence, and then you've committed another theft. So that would be 3 separate instances of burglary.
Okay.
You don't have to steal a toaster and beat around, and beat up your ex-girlfriend and commit a felony.
But family violence, I think, in code includes like
It-
criminal damage or anything. Like if you come
It-
in there and throw the TV against the wall and destroy that, that's family violence, I believe.
Mhm.
Is that correct? So it doesn't have to be family violence we think of as being against a person, but it could also be against property. Is that correct in code?
Well, I mean, it was a misdemeanor. The point is we're trying to raise it to the level of a felony because we do think it's egregious because, whenever these intimate partners, these acts of violence are occurring between intimate partners, they're not just saying, I can break your TV or look, haha, I just broke your TV. They're saying I can break your TV, I can break you. There's always kind of the underlying emotional aspect to the offense that makes it especially terrifying in these situations.
Okay.
Okay, thank you. I don't know who was first. Number 7.
Thank you, Madam Chair, and thank you for bringing this measure. Isn't it true that the only portion of code section that's changing is what's underlined?
Yes,
and
ma'am.
this is just making damage to a human being equivalent to theft.
Yes.
Thank you.
Okay, and number 17.
Yes. There are felonies that are acts of family violence, right? Aggravated assault, aggravated battery.
Yes, ma'am.
So you're only talking here about the misdemeanor acts of family violence.
Obviously, it would be at the discretion of the prosecutor, but he could charge, depending upon what he wanted to charge, predicated upon the arrest warrants that were secured by law enforcement.
Right, but so if you're, so
It
for-
wouldn't make sense for him to usurp a family violence felony for a burglary felony for an act of family violence, to my mind.
Right, but my concern is that you may take a criminal misdemeanor, a criminal trespass for a TV, and now it's become a felony punishable by 1 to 20 years versus what should still be a misdemeanor.
I don't know how stealing, because it's enter with the intent, without authority, and with the intent to commit an act of family violence. I don't think stealing a TV,
Not stealing, breaking, that was,
the criminal trespass. I don't think you have to commit, you have to commit an act of family violence once you get in there. Getting in there can't be the act of family violence.
well, no, you have to intend to commit the act of family violence. It doesn't actually have to be completed. I'm just concerned about felonizing what is a misdemeanor. Because there's simple assault, simple battery, criminal trespass. They may not rise to felonies. And so your intent to go in and, mess up the TV shouldn't be, because you're committing, quote unquote, an act of family violence shouldn't felonize you at that point. That's my concern.
So, in other words, you're saying that somebody breaking into a house because we're putting the offense of current and former spouses, romantic partners, and/or family members. Somebody breaking in and stealing there, you don't think that should be included?
No, I'm not. I'm just trying to figure out the line. Right. I'm against family violence too. I represent victims of family violence all the time. I also don't want to make something a felony when it's not a felony. I think this is what that might be doing.
Okay, all right. Number 4.
So I guess maybe, and I'm trying to think about how it would be interpreted on the street, and I would hope it would be interpreted properly, but I'm thinking that the only way that family violence is included in this manner is, and let's say, council, please correct me if I'm wrong, this has to have the combination of the burglary plus the family violence happening at the same time. They can't be exclusive of one another, right? Like, under this bill, both things have to happen in order for it to qualify as burglary, family violence, correct? Or not correct? But burglary and family violence has to happen.
Correct.
Or. But family violence, I mean, the burglary has to be in process.
In order for
No,
the family violence side to activate it, right?
For the formation of the burglary, you have to have the intent. So they're saying the intent is to commit an act of family violence. That triggers the burglary.
Okay, all right, y'all, time out. We're going to hear from Ledge Council.
I interpreted, and I thought the intent, Madam's intent, was to expand the offense of burglary to also include when you break and enter into someone's house, you can steal something, you can have the intent to beat them up or have some other felonious intent, or the breaking in and entering in their house is the felony. The family violence is the intent. So I'm breaking into your house. Whatever I intend to do, I'm already at a felony. So if I am breaking into the house or trying to sneak into the house to beat up or harm my ex-spouse or my ex-partner, that would trigger it. It's still a burglary. The family violence is elevating it because the intent to break in the house, which you've already done and already committed the offense of burglary, with the intent to harm someone inside, elevates that. So it's already a burglary offense. However, if you're not, if you go inside the house and you don't steal a felony amount of things, or you don't aggravate, have I guess damage or fight with someone to the level of aggravated assault, then if you just go in there with the intent to break and enter and harass, harm the person, then that would trigger the statute. That's what I thought Madam Chair's intent was.
Yeah, that was my intent. Okay, all right, number 3.
Thank you, Madam Chair. I guess what I am looking at is we're thinking of family violence as a spouse or a partner, but what I'm reading, and I'm just reading online, so forgive me if it's not exactly the code, but it talks about any person you live with. So I'm assuming that is a former roommate. It could be a family member, it could be a spouse, it could be anybody you live with would be family violence when you come back. And then it talks about what is considered family violence. It talks about battery, but it also talks about criminal damage. So I used to have a college roommate. We get an argument. He's got my PlayStation. I come in there and I throw that $599 PlayStation against the wall. Am I committing a family violence felony, and am I being escalated under this?
I am going to be I'm going to be offering as an amendment limiting language.
Okay.
To between current or former spouses, romantic partners, or family members. So because whenever I was talking about the amendment in the very early parts of the discussion, I was specified I did not want to get into the roommate kind of, I think once upon a time that was kind of euphemistic for romantic partners. So seeing no further questions, number 8, I'll recognize you for a motion.
I make a motion to pass.
Okay, there is a motion to pass. Is there a second? Second. All right, several seconds. I do have an amendment. And I know Jill with Gactel was also going to be looking at the language. So the language that I have come up with is at the line 9, at the end of family violence. Including specifically offenses between current and former spouses, comma, romantic partners, comma, and family members. Therein, he or she enters or remains within occupied. Is that language good, Jill, or do we no? Little tweak. I'll recognize Jill at the podium, so she'll stop dancing.
Can you make it only including? Because if you
Only
say
including.
it's going to bring in the roommates and everybody else.
Well,
that's
see,
in the
I like
list.
specifically offenses, but if you're saying only including instead of specifically, I will have that change. So only including.
Oh.
What?
Yeah, I didn't mind your specifically, but if you could
Yeah.
read it back one more time, sorry.
Or an act of family violence only including offenses between current and former spouses, comma, romantic partners, comma, and family members. Therein, he or she enters or remains within an occupied, unoccupied, or vacant dwelling.
The only other thing that I might suggest you change the "and" before the last clause to an "or," because I don't think you're trying to say it has to be
Okay.
between all those people. It could be any of those people.
Okay. So the amendment is further changed to, and I'm only going to read the amendment, only including offenses between current and former spouses, comma, romantic partners, comma, or family members, comma. Therein, he or she enters or remains within an occupied, unoccupied, or vacant dwelling.
Thank you.
Yay. Teamwork. Go team. So, is that, you've got it? Good? Okay. All right. So that's the amendment. All those in favor of the amendment, please signify by saying aye.
Aye.
Any opposed, like sign? Okay. So the amendment passes. So now we're back to House Bill 509. There is a motion to pass for LC 480860 as amended by the committee. All those in favor of the passage of the bill as amended, please signify by saying aye.
Aye.
Any opposed, like sign? Okay, so that one's passed. Where's my to-do list? Okay, y'all hang with me. I'm now going to present House Bill 460. This basically has to do with the rights of children in guardianship cases in juvenile court. Lines 13 through 15 add a dependent child who's represented by a court-appointed counsel and who is the subject of a legitimation petition. May be represented by the same appointing counsel in the legitimation matter. So that just allows for continuity for the attorney in those matters. On line 21, we're adding a child may obtain a court-appointed attorney for the hearing to determine whether or not continuation or termination of the temporary guardianship is in the best interest of the child. Line 27 adds any custodian or guardian subject to a sworn complaint or affidavit and any other respondent to a proceeding under this article shall have the right to an attorney at all stages of the proceeding under this article. The court shall, in lines 30 through 31, lines 30 through 32 add, and any child receiving extended care youth services from DFACS at all stages of the proceedings under this article. This actually came about because some judges were interpreting that as judges for everybody for everything. Which was making it very onerous on the counties having to pay for that. And in lines 41 through 42, it specifies only when a child is taken into custody under exceptional circumstances can an affidavit or sworn complaint be filed. And lines 50 through 56, the trial court may appoint an attorney for a child at all stages of the proceedings under this article with the child's consent. If a child does not have an attorney, a child shall be informed prior to any hearing of their right to have legal representation and shall be given the opportunity to obtain an attorney of his or her own choice, obtain a court-appointed lawyer in the court's discretion, or waive the right to an attorney. So we're basically expanding and clarifying some of the rights that children have for attorneys whenever these very significant decisions regarding their welfare and where they're going to live, who they're going to live with, those sorts of things are going to be represented in court. So it's very important, I think, that the child have a voice in that. We do have somebody who has signed up, Fran Calhoun from Fulton County. Ms. Calhoun, if you'll take the podium.
Yes, ma'am.
Thank you, ma'am.
Madam Chair. And I want to thank you for your leadership. Good afternoon to the committee. We are grateful for this bill because we believe that it will help our juvenile court and our child attorney's office. It provides clarity for our judges. And what is happening in practice is that in most cases, these children do receive counsel and representation, but it's just not codified in Georgia law. And so we want to make sure that there is clarity there and that there's no exposure for, of course, our jurists. And so we certainly ask your full support, your favorable support of this measure, which we really believe is just clean up language for what is already being done. There are no additional costs to be borne. And so we do hope that you'll support it.
Okay, thank you, ma'am. Number 17, do you have a question for the witness or the person at the podium? Not really. Okay. There you go.
Do the judges want to require an attorney to be appointed? I mean, should the may be a shall?
Well, we decided on a may because, of course, all of the counties around the state of Georgia differ in terms of their size and their abilities. And so we thought that it would be a little more amenable if we went with a may instead of a shall. Yeah.
Thank you.
Okay.
Thank you.
All right. Thank you. Any other questions for Ms. Calhoun? Okay. Seeing none. Thank you, Ms. Calhoun.
Thank
I
you,
appreciate
ma'am.
your support.
Thank you.
Ladies and gentlemen of the committee, do you have any questions for the author of the bill? I think I've just tired y'all out. And so y'all are just tired out and questioned out. Ms. Ladd, I'll recognize you, I think, for the purpose of a motion.
That's right. Make a motion to pass.
There's a motion from Ms. Lott and her partner in crime, Representative Wade. All those in favor of the passage of House Bill 460, it is LC 480870S. Okay. Okay. Oh, I do apologize. You're right there. You got lost in all the 462s. So if you'd like to take the podium, introduce yourself to the committee.
Well, first, thank you, Madam Chair and fellow committee members. My name is Gabriel Carter. I'm with ACCG, representing all 159 counties. We're not opposed to this bill, but I just did want to raise one concern about, I don't have the full version of the sub, but in the original bill, lines 118 to 120, that talked about the court being able to authorize payment from the county funds for the service and necessary travel expenses occurred upon those persons summoned.
That's not in this bill.
That's not in there? Okay.
Nope.
We're good. Thank you.
Sweet. Awesome. If only all the conflicts were shared that way. Yay. All right. So we have a motion to pass on House Bill 460, LC 480870S. It will be offered as a committee sub that I have just presented to you. There's a motion to pass. There's a second. All those in favor, please signify by saying aye. Aye. Any opposed, like sign. Motion passes. Thank you very much, everybody. And we only have one more bill. Only one more little measure. And I don't want to fatigue my poor committee. Y'all have heard, the ones that have stuck with me and have heard this. have heard me talk about this a lot, and so I don't want to fatigue y'all. For the new ones, I'm just going to kind of breeze through the bill and just kind of say this is the implementation committee. This is where we're just raising the age. Basically, we're striking 17 and 18 to 18. It was my understanding, just to give you a little kind of background on this, this raise the age was actually meant to happen in 1973. And the state of Georgia decided at that point that they, quote unquote, didn't have enough money. So they didn't change it in 1973. There was an effort again in 1978 to change it. And that didn't happen either. We're over 50 years behind the state of Alabama on this issue. We are one of three states that still adhere to this antiquated practice. And as science has shown us more and more about juveniles and how they're capable of making good choices, but they just don't make good choices because their brains are not fully developed yet. They are unduly influenced by their peers, and they have extraordinarily poor impulse control. And that's a physiological fact. There's not much we can do about that. So that's why we're once again working on raise the age. And it does not affect the Senate 440 cases, what are called the 440 cases, or the 7 deadly cases is what I knew them as. It doesn't impact those. So those have original jurisdiction in Superior Court. They will still have original jurisdiction in Superior Court. This just kind of operates outside of that and doesn't touch that. I have added criminal gang activity. You'll see that on line 189. And participating in criminal gang activity. That was something that my prosecutors and law enforcement were very insistent on, so I added that in. And I also added in second offenses, and you'll find that on line 193. So if this is somebody's second bite at the apple, then, if they've already been adjudicated in juvenile court, obviously it didn't take, so to speak. So that's why we're going back. The first part of the bill is just the implementation committee. There's a very long implementation committee, and actually there's a kill switch in the bill, which means the bill will not go into effect unless it's fully funded. Because we want to make sure that whenever we rewrote the juvenile code in 2014, we just kind of rewrote it and dumped it into our county's laps and gave them a very small amount of money to operate their juvenile courts. And so we've been trying to kind of claw our way out of that. So we're very insistent that this be fully funded at the state level. So the rest of the bill are just changing 17 to 18 throughout the bill. There's no new substantive information. So there's the bill in a nutshell. It kind of sets through the implementation committee. It sets through the, kind of what the committee will do, timeline. And it does have a stretched out timeline for implementation to allow for the implementation committee to create the infrastructure that's going to be necessary for the implementation committee. We do not want to commit the errors of the past. We want to have this fully funded. We want to have, the infrastructure in place. I'm not saying it's going to be perfect. Nothing ever is. It's government. But, certainly we want everything to be well resourced and as prepared as we can possibly be on the measures. So that's the bill kind of in a nutshell, kind of a thumbnail view. I know lots of people are going to come up and talk about the bill. So you're probably going to get different viewpoints. And I'm happy anytime somebody has a question or raises a question, feel free to chime in and ask a question of the author. You don't necessarily have to, if somebody at the podium kind of raises something and you have a question of the author, then feel free. I am always available, to answer any questions. And sometimes I get a little too in the weeds on the numbers. So happy to do that. The first one who has signed up is Mark Hayden with R Street. Mark, there you are. I can't see because of that big poll, so I apologize if I miss anybody.
Well, Madam Chair, members of the committee, I really appreciate this opportunity. My name is Mark Hayden, and I'm the Director of State Government Affairs at the R Street Institute, which is a free market think tank that supports limited, effective government in many areas, including criminal justice reform, and that's why this bill is of special interest to us. Now, I've testified on this many times, submitted testimony, and as I've said before, Georgia's one of only 3 states that still automatically prosecutes all 17-year-olds as adults in the criminal system. Now, there was a time when numerous states did this, but over the years, many states have moved away, leaving only Wisconsin, Texas, and Georgia who still do this, and they moved away for good reason. Trying all 17-year-olds as adults is patently problematic. After all, if these individuals can't be trusted with opening a bank account or buying a lottery ticket, then why should they be held to the same level of responsibility as adults? And in my opinion, they should not. And this policy also burdens minors with criminal records that last their entire lives, and will track them down, follow them, hurt their futures, whether it is their future rights and liberties, getting a job, going to school, getting even student loans can be affected by this. But, Madam Chair, as you mentioned, science does suggest that there's a lack of degree of culpability here. 17-year-olds, their brains have not fully developed yet. So they have problems controlling impulses, and they're not able to calculate cause and effect quite as quickly and as ably as many of us in this room can. And besides all these issues, punishing 17-year-olds as adults wholesale is just unnecessary, because in other states, there's ways around this. There are discretionary waivers that can be used that permit you to try minors as adults if there are particular circumstances that are particularly concerning. And these are many issues that other states have weighed, I'm sure, as they weighed whether or not to raise the age of adult criminal responsibility, but particularly they looked at the economic impact, which I wanted to raise. A fiscal note in Connecticut claimed that raising the age of adult criminal responsibility would cost an extra $100 million a year. Massachusetts said that it would cost almost $25 million more a year as well. Illinois said that their juvenile detention centers would swell by about 35%. Obviously, that would cost a lot of money. And New Hampshire policymakers said that they would need an additional $5.3 million a year to be able to roll out this program. Despite all these scary numbers, they plowed forward and they raised the age to 18, and then they found out that these budgetary concerns were actually overblown. So in Connecticut's case, their juvenile justice budget actually contracted by $2 million. Massachusetts' estimated projection was actually $9 million too high. And when accounting for inflation in Illinois, their juvenile justice budget remained about the same from 2010 to 2016, and New Hampshire approved the measure without increasing funding whatsoever. And a Wisconsin study, if you want to look at more longer-term prospects with raising the age, a Wisconsin study estimated that for every 1,000 youth returned to the juvenile system, there's going to be a $5.8 million in direct savings each year through reduced law enforcement costs, court costs, and losses to victims. And PolitiFact also found that for every dollar invested in raising the age, there's a return on investment of $10. So pegging the exact costs in Georgia, that's not an easy proposition, but I think looking at other states, we can see in the short term, sure, there may be an investment up front, there may be some reallocation of resources, but the impact to the state budget would be probably negligible compared to other states. And in the long term, I think there's many benefits. So in short, Madam Chair, appreciate you bringing this bill. If there are any questions, I'd be happy to field them.
Thank you, Mark. I appreciate that. Ladies and gentlemen of the committee, do y'all have any questions for Mr. Hayden?
Thank you.
Seeing none? Thank you. I appreciate your testimony. Next up is Mike Mitchell with the Georgia Sheriff's Association. Mr. Mitchell.
Good afternoon, Madam Chair. Thank you for letting the Sheriff's Association express some of the concerns that we have with this particular piece of legislation. And also want to thank you for making some time Tuesday morning for Terry and I to come to your office and meet with you. You were very accommodating and receptive to some of the concerns that we had Tuesday morning, so thank you for that. We also respect the fact that we know that this is a matter that's very important to you. It's one of your passions, so we completely respect that. Just want to highlight some of the improvements, reiterate some of the improvements to this particular piece of legislation that you mentioned, Madam Chair, in your opening remarks. We do like the fact that gang-related activities and repeat offenders will remain under the purview of Superior Court. We do like the fact that there is a delayed effective date on this legislation. And we do like the fact that it is subject to funding. But with respect to the funding, we did see in the legislation that there is reference or language to funding in the state budget, but we did not see any reference to funding on the local level. So obviously our concerns would be with that money trickling down to the local level to the county sheriff's offices. So those are definitely positive points that we want to highlight, and those are that's new language that was not in the legislation previously. Some of the concerns that we have, and these are not new concerns. I think the association has had these concerns historically, but bed space with DJJ, that is an issue currently. And we do feel that bed space will continue to be an issue as we add a new age group to the definition of juvenile offender. So I know that DJJ currently has a good bit of staffing constraints, which allows them not to be able to house as many of the youthful offenders as they possibly could. We do understand that there is an implementation committee, a provision for that in the legislation, but if DJJ is currently having staffing challenges now, I'm not sure what can be done to necessarily improve their staffing constraints based on the recommendations of the implementation committee. A second concern that we have, and this is a big issue for sheriff's offices here in the state of Georgia, relates to transports. Whether it be juvenile transports, mental health transports, sheriffs have to dedicate an inordinate amount of resources and time transporting juveniles from to and from youth detention centers, regional youth detention centers. And we see that, again, introducing this new age group into the definition of juvenile, that's going to probably substantially increase the number of transports that our sheriff's offices have to do. The third concern that we have is more of a fundamental concern, and that is just, again, adding a new age group, 17-year-olds, into the mix with our current juvenile offenders. Some of the 17-year-olds obviously are more streetwise and more savvy than some of the younger juvenile offenders, and so our concern is just what negative impact that could have on younger juvenile offenders, taking up an additional bed at a facility that could be used by a younger offender, participation in a program, taking up an additional spot in participation of a program. So these are some very broad concerns that we have with this particular piece of legislation. And again, I don't think they're new concerns from the standpoint of the association. So I'll be happy to answer any questions that the committee might have.
Okay. Thank you, Mike. I just wanted to comment on a couple of things. I know DJJ is constrained by staffing, but if you look from years 18 to 20 prior to the pandemic, our YDCs operated at 71% capacity. So I don't think that I don't think adding 17-year-olds are going to necessarily make up that 29% capacity. And I've got that report for you if you would like. I've made some notes on it, so I'll have to give you a clean copy. There's always been, additional capacity, shall we say. At our all YDCs, it was 71%. Just to kind of pick out a couple, CRISP is at 73%, Dalton's at 52%, Metro is at 58%, Savannah's at 55%, Wilkes is at 42%. So, there's always, I don't think capacity is going to be, and I think the staffing issue is there, and I think it's going to continue to be there whether we raise the age or not, and that's certainly something I think we need to address through appropriations. Quite frankly, they have like a 90% turnover, 95% turnover. It's just disgraceful. So I think that could be ameliorated somewhat by the appropriations process. As for the transports, North Carolina did a contracting thing with juveniles. So that's kind of how they address some of the transport. They actually contracted some of that out to, third parties. So I think that's something that certainly the committee could look at. And with that pushed back implementation time, we certainly have time to look at that. And as for the funding, you mentioned that the funding is all state funds. That's what I intended. I don't intend for it to cost our counties any money. I don't expect your sheriffs to lose $1 of their current budget on this issue. I want to see them made whole, and whatever margin this goes over. If their current budget's $100 and it's going to cost $10 to raise the age, I want that whole $10 to come from the state. I don't want $2 from Wilkes County. I don't, I don't want their budget to be reduced by any sum. I want it to stay the same, and the state to fund all of that. So I would just, those are my comments there. And number 9, you've been very patient.
Thank you, Chair Lady. So I want to just kind of touch back on a point that you made. I think it's a concern that I have as well, but we know how strongly Governor Kemp has worked to change the landscape of gang crime in Georgia. I think I understand what you were saying was that adding these 17-year-olds into these juvenile detention facilities, that they are leaders, recruiters, influencers, and do you have evidence of that actually occurring, that the kind of the stronger take charge? Do we then see folks coming out of these detention centers and getting into crime greater than what got them there in the first place because of those relationships that were built in the detention centers?
So I don't have any information with me here today to answer your question. That's something that we can certainly follow up on and research. That might be a good question for maybe someone at Department of Corrections, since the 17-year-olds now are under Department of Corrections and not DJJ. But it is a concern among the sheriffs, because some of the feedback that we've gotten from sheriffs is some of the 17-year-olds that they interact with and deal with, it's some pretty serious stuff. It's pretty scary stuff that they have to deal with the 17-year-olds. So we just concerned fundamentally that we don't want to be introducing a bad element into the Department of Juvenile Justice system, or YDCs and YDCs.
May I ask one more question?
If I could just interject, 17-year-olds charged with any gang offenses would not be included. They would still be adjudicated in state and superior court, as they are now.
I did see that ad. Thank you. That's great. I agree with that. Secondly, the number of 17-year-olds in the system currently, as it is, are there regions of the state that just have greater populations? I would imagine, as goes with the rest of the population, certainly the Atlanta area I guess it would be proportional, but is there anything that you're watching with the number of 17-year-olds? I know that, of course, my sheriff as well is very concerned about this, and I have to listen to my area on this matter, really. So I've struggled with this one for years. The chairleading has been doing a great job in really trying to add language that has really tried to answer a lot of these questions, but I do know that my sheriffs and honestly my juvenile court judges have concerns as to what's happening. So do we know, are there areas where maybe the 17-year-old population is going to affect certain areas more than others?
don't have that information. I do have some numbers that we put together in 2019 and 2020 as we were working on researching a previous version of this bill, House Bill 440 from 2019. And the numbers that we pulled then, and of course these numbers are a little dated, but 2019 and 2020, there were a total of 13,370 arrests of 17-year-olds for felony and misdemeanor offenses. So now I know that this particular version of the bill will probably weed some of those out because of the language about the gangs and the repeat offenders. But we are looking at adding several thousand more individuals under the definition of a juvenile offender. And that was the figure that we put together in 2019 and 2020.
Thank you. Thank you.
All right, thank you. Appreciate it. Number 13. Wow, I had a lot of questions, and a lot of questions went away. So, Ms. Representative Lott, you, and I just dropped another one. Okay, all right, Vice Chair, I will recognize you for a question.
Yeah, sorry, I'm kind of catching up on the repeat offender thing. How do we treat? What's the triggers for that to I guess have them continue to be treated as adults at 17?
Mm-hmm. Yes, they would still, if they have been, if there has been a prior arrest of that juvenile, then they would be adjudicated in the state and superior courts just like they are right now.
Okay, all right.
Number 3.
Thank you, Madam Chair. And that's what I wanted to comment on. I guess you had mentioned those numbers as far as offenses. I'm assuming that typically you have a smaller number committing a lot of the crimes. So I would think that if we, with the addition of the second or subsequent event, that it would take a lot of those out of the case. That what we're trying to do, I'm assuming with this bill, is only have those individuals who have made a bad mistake or a bad choice, and not the career criminals. And I think with the gang activity and the repeat offenders, does that help in your mind with weeding out the career criminals with the people that make mistakes? Does that help somewhat?
It could. It could definitely impact that number that I just provided. Okay. We have not had a chance to really drill down to that level yet. And unfortunately, some of the stats that I have are just a little bit dated. But we can certainly rerun those numbers and account for the new provisions that have been added. So it could definitely impact that number.
Okay, thank you. Any more questions for Mr. Mitchell with the Sheriff's Association? Seeing none. Thank you, Mr. Mitchell. I appreciate your testimony. And next we will hear from Christina Anderson. If you will, come up to the podium and introduce yourself to the committee, please. Thank you.
Good afternoon, Madam Chair and committee members. My name is Christina Anderson, and I'm testifying on behalf of the Barton Child Law and Policy Center. I am the Child Law and Policy Fellow. Thank you. I appreciate the opportunity to speak here today. For almost a decade, we've supported the policy behind raising the age, and we remain committed to aligning Georgia with the other 47 states that set criminal responsibility at 18 years old. Just like it's been mentioned before, we are behind our southern neighbors. The momentum that has been built over the past years for this initiative, though, is really a credit to your steadfast commitment, Madam Chair, and we do appreciate all that you've done to educate the public, to educate us, and to bring others along. We've known for a long time that kids are different, and our laws already generally reflect that. We give kids a chance to receive treatment and be educated while they're held accountable in juvenile detention centers, because the goal is to restore them to their communities with a renewed sense of responsibility and hope for a better future when they're out. And you've stated it before, Madam Chair, raising the age is the right thing for our 17-year-olds. Revising Georgia law to let 17-year-olds be held accountable in the juvenile system, where they can receive age and developmentally appropriate services to help in their rehabilitation, is a logical and long overdue step. It's a step that promotes public safety and stronger communities. Raising the age is the right step because it could help kids from falling into the cyclical trap of recidivism and collateral consequences that we know come with the adult criminal system. With the step taken in this version of the proposal to raise the age, we just have a couple of concerns about the policy lines being drawn and the bill's mechanics. I like to think that we're not all too far removed from being a child to remember that children have less capacity, less developmental capacity for reasoned judgment and more impulsive behavior traits, and they just take greater risks. Kids are also susceptible to being influenced by others, and so they do dumb things that are sometimes unlawful things as well. But when they do those things, it only reinforces the very vulnerability of being a child. And drawing policy lines that requires the treatment of a child to be like that of an adult, like those found at lines 126 through 131 of this bill, it disregards the vulnerability of children that Raise the Age as a policy seeks to protect. This bill's mechanics also raise a question of procedure. The jurisdictional carve-out at lines 126 through 131 also suggests that the Superior Court would hold a preliminary hearing on the gang charges, but it doesn't provide. I'm sorry.
I do apologize if I may interject.
Yes, ma'am.
You're dealing. We're working from House Bill 462, LC 28.
Yes.
0590S.
Got it. And you guys have something completely different right now.
We struck that.
Oh, that's great then. I love that as well. So then our only concern is, like I stated before. Oh, thank you. I appreciate it. I'm going to look at that later just so I don't get off track.
I apologize. I didn't get it until late this afternoon.
It's okay, Madam Chair. Thank you. I appreciate it. But like I said before, we don't want to risk the vulnerability of children with this bill, excluding certain kids and including certain kids. The Barton Center believes in treating all children as children, which is, we believe, is the principle behind Raise the Age in the first place. We appreciate your willingness to hear our perspective on the added features of this version of that policy idea, and I will entertain questions if there are any.
Okay, members of the committee, number 15.
Thank you very much for your testimony. I'd be curious on the Barton Center's position on the waiver of juvenile court jurisdiction. So in the new bill, section 2.6, and specifically the waiver of children who have been committed criminal gang activity.
Thank you, Representative. I am flipping there.
So basically, these are carve-outs for children, as I understand it, children who would not be treated in the juvenile system, but would go to the adult system.
She's looking at lines beginning on lines 183.
Okay.
We usually look at line numbers.
Line numbers.
Thank you. So this is the carve-out that we were talking about. This carve-out tends to be unworkable. We've seen it in other states, and if you would like to know those states, I can get that to you later. But we've seen it in other states where these kinds of carve-outs for certain children who commit certain acts are it's just unworkable, and so that's our stance on that right now.
In what ways is it unworkable?
I can't answer that best right now. Again, I can definitely look at that information and get it back to you as soon as possible, though.
Thank you.
Yeah.
Any other questions for Ms. Anderson? Seeing none, thank you, Ms. Anderson. Appreciate your testimony. And next up is Maisie Lynn and Jill with Georgia Association of Criminal Defense Lawyers. Oh. Whomever would like to come and testify. We're not picky. We don't play favorites here.
Members of the committee, my name is Jill Travis. I'm with the Georgia Association of Criminal Defense Lawyers. This has been a long time coming. It's really, really been a long time coming. I know at least with the juvenile code rewrite back in the early 10, 11s, 12.
2014.
Thank you. This idea was present, and I just can't thank the sponsor enough for all the work that she's done for all of these years, and especially working on some of the revisions to the substitute and the changes that were made. I know it's late on Thursday, so I'm just going to say thank you. Please vote green on this. We would be much appreciative of it. And again, Madam Chair, thank you for all your work.
Thank you. Appreciate the encouragement. So, ladies and gentlemen of the committee, do you have any questions for the author? Number 17. Okay. And what is your motion?
Motion to pass.
There's a motion to pass. Is there a second? Multiple seconds. So motion to pass, several seconds. Is that what everybody else wanted to do? Do you have a question? Okay. Representative Lott, she has a question.
Thank you. I do have a question for the author, and I would, I just need a little bit of clarity. Is there flexibility currently that a 17-year-old could end up in the juvenile court system versus being treated as an adult?
Yes. No, not as it is right now.
So any crime,
as a matter of law, they go to state or superior court.
And then the superior court does not have any ability to transfer that to the lower court.
They can, but they don't.
Okay, but because I am looking at line 154, which I just wanted to get clarity on that because it does say may transfer, and is that what that's old code, so that's not anything you made changes to. I just wanted to clarify that was still a possibility.
Yeah.
Okay.
They can.
Thank you.
But yeah, don't. Partner in crime, Representative Wade.
I'm not going to sit by her next time. She's had good questions too. So just for clarification,
sure.
You know, I'm sympathetic to the chair lady's work, and I overall I like the aim of the bill and what we're trying to do and accomplish. But is with the exclusions of like the situation surrounding gangs, and being a person who has a background in schools and teaching, son of two teachers, my spouse is a teacher, are there situations in which there are certain crimes that have not been mentioned? If a 17-year-old who is 17 and 10 or 11 months and they commit a certain crime and that hasn't been excluded, that there is some type of discretion that the judge could rule this really ultimately needs to be. And I'm just asking the question because there are certain crimes that I don't want to go into discussing the gravity of them. I'm happy to offline. Have we fully thought through that, and is that exclusion enough?
I would just direct your attention, and this may answer your question. It's on line 6. It's on page 6, and it talks about the superior court shall have original jurisdiction, and that's what we commonly refer to as our 440.
Okay.
And you can kind of read down those crimes, and those would still be adjudicated in superior court. They are now adjudicated in superior court, and they would continue to be after the passage of this bill.
The age trigger would still be such that depending on the crime, they could be referred to DJJ, or they could go to, okay, then I'm fine.
But the original jurisdiction is in superior court.
Got it. Okay. All right. I'm fine.
They start there. Bad judge and Cobb. And there was a judge who would like to be heard. I'm sorry, I was not trying to make a play on your name at all. I just couldn't read your first name. So Judge Hurd would like to testify.
Thank you, Madam Chair. I am Render Hurd. I'm the judge, the juvenile court judge of the Tifton Judicial Circuit down in Tifton and surrounding counties, and I'm currently the president of the Council of Juvenile Court Judges. At this point, with all the changes in the bill, the council feels that we are in support of this measure at this point. With the implementation committee, as you all know, I don't need to tell you, the devil's in the details. And so we are very much looking forward to trying to iron some of those out. We are probably, next to psychologists and social workers, we are the most trained people on brain science and adolescent brain science. They sort of drill that into our head. We are very well aware of the need for this. We also see in what we do the impacts that delinquent and criminal activity have on our community, and have to balance that every day as well. One of the reasons that I wanted to be here today was, although I don't ever want to consider myself an expert, we do this all day and every day, so I wanted to be here to maybe answer some questions that you all have about how this may look, or for instance, in the representative's question before, there are certain circumstances, even in without SB 440, when we can transfer currently of, say, a 16-year-old. There's a list of factors that we could transfer up if the proper motion is made and the state proves that the child, it can't be served as a juvenile, it's too dangerous to be served as, very. So there are that is a limited use thing. It's not used very much, so that is still available. I'm assuming, I haven't specifically seen that in 462, but I'm assuming that's still going to be in place for this, and with that assumption, it would provide those circumstances. In 10 years, I've done it twice, so it is a limited thing, but we do have it at times. And so, but I just wanted to express that, and to be here for any questions that you might have.
Okay, and you've gotten some. Number 3.
Thank you, Madam Chair. I guess I have a question on lines 154. The representative alluded to this. So right now, if it starts in Superior Court at 17, it can be transferred back to juvenile court, is my understanding. A 17-year-old can be transferred back, right?
That is correct.
Can an 18-year-old be transferred back to juvenile court?
No.
Okay, so if that's the case, then...
Well, no, 17-year-old cannot be transferred back under the current laws.
Okay.
It's an adult, and it's the definition. It's how we define child in the code. Currently, it is defined as 16 years under 17 years of age and alleged to have committed a delinquent act. And so in that case, it would be just the under 18 years of age. And so we don't get those particular, they're adults, they're always adults. And we can go the other way, and that's what I was referring to earlier. We can do the other way, but it never comes back down. What can come down in certain situations is the SB 440 kids who, you got a 14-year-old that commits an SB 440 act, the Superior Court can transfer that down to us in those situations.
Okay, so in this case on lines 154, and I apologize, but so that's up to 18, not including 18-year-olds. So when we talk about transferring a case involving a child 13 to 18, that is up until the age of 18, not including an 18-year-old.
I think it generally says under the age of 18, and that's where how the child is defined, I think, in the other part of the bill. And I'm sorry, I'm just getting the new version, so let me look specifically. At 154, did you say?
Yes, 154. And 154, yes.
All right. Yes, those are the ones that can transfer down. Okay. And then I was unclear about that. Those are the ones in the SB 440 kids that can be transferred down.
So that would be up to 17, not including 18.
That's correct.
Okay, thank you.
That's correct. Up through 17.
Okay, thank you. Members of the committee, do you have any other questions for Judge Hurd? No? Okay. Yes, no, yes, no. I think they just like watching the light go on and off. So no other questions for Judge Hurd, just wanted to make sure. All right, thank you, Judge Hurd. I appreciate your testimony and the work that we continue to do together. So, all right, there is a motion due pass. There were several seconds.
I'd like to make a motion if that's
okay.
So thank you, Madam Chair, for your work on this bill. I'm a big fan of this bill, and I absolutely believe that these children, because they are children, have the ability to rehabilitate. And so my concern is with lines 183 through 185 of this bill, when we're talking about carve-outs from the juvenile system for children who have committed acts of gang activity. And so I was looking at the gang activity statute. I mean, it sounds like a 17-year-old who was stalking or who committed statutory rape would fall under this exception and then would get put into the adult system. I also have concerns as far as a disparate impact on children who are coming from particular communities under the statute. So, you know, with the idea that children are children and everybody is worthy of rehabilitation, I would make a motion at this time, if it's appropriate, to strike lines 183 through 185 of the bill.
That would be, you're welcome to make the motion. It would be an unwelcome motion. The chair did not make that inclusion lightly, but it was predicated upon, palatability to certain people who were not for the bill, and maybe they're for the bill, or maybe they're just not quite as loud in their opposition of the bill. So it would be an unwelcome motion, but you're welcome to make it. The motion on the floor is to strike lines 183 through 185. Is there a second?
Amend the bill. To strike those lines.
Okay, motion dies for lack of a second. So there is a motion to pass on HB 462 LC 280590S. There is a motion to pass. There were several seconds. All those in favor of the bill, please signify by saying aye.
Aye.
Any opposed, like sign? Thank you. Motion carries. Thank you, ladies and gentlemen. We are adjourned. I